All right, welcome everybody to our webinar today. My name is Rachel Sterling, and I will be kind of navigating through everything. I'm an attorney here at Homeline, and today we're going to be joined by Jess Mickelson, who is going to give us some insights as a landlord attorney, which is a slight departure from our normal way of doing things here at Homeline. We are tenant focused generally, so it'll be thought it would be nice to have some viewpoints from the landlord side of things. We will also be joined by our managing attorney and hotline director, Mike Farah. Again, thank you for joining us today. We will go ahead and get started here in just a minute. All right, if you are looking to ask questions while we are going through all things or something comes up, we do have some pre-submitted questions, but there is a Q&A option down at the bottom of your screen. If you can submit questions via the Q&A, that would be really great. If just because I tend to miss things in the chat, and then I will feel bad when I'm looking through it later on and see that I've completely missed an important question. So please use the Q&A function. That's the best way to get questions asked. We will reserve quite a bit of time at the end of our 90 minutes to be able to go through those questions. All right. Okay, so then without further ado, I am going to do just a quick regular song and dance for what is Homeline. So Homeline is a nonprofit that we help serve tenants across the state of Minnesota, providing free legal, educational, and advocacy services. We've been around for 30 years now, so we've helped a lot of folks over those 30 years. Our primary program is a free and confidential hotline. We do offer those services in 4 languages. Those languages are Spanish, Somali, Hmong, and English. So those are all of the numbers there. We also have an email and attorney option if that's your jam instead. Folks can email us by going to our website, homelinemn.org/email. All right, so that is the end of my song and dance portion. So now I'm going to turn it over to Jess. Jess, if you want to introduce yourself a little bit, I think we have, Homeline has a long history with you. I know that you worked with us before I started here, but not before Mike started here. And so but you then moved on to CMLS, right?
Yes.
And then are now with, and I apologize, I did not know how to pronounce this properly. Is it Heller and Thien?
Yes.
Okay, that I was like Thien, Thien, I don't know.
Okay.
So
The trick question, you passed.
Okay, perfect. What's my prize? My prize is that I
Well,
get
we'll
to go
talk
on mute,
later.
and yeah, I get to go on mute,
Yeah.
and I can forward the slides, and now I can turn it over to you now. So thank you.
Yeah. Thank you for having me today. I used to work with Homeline, as Rachel discussed. I used to be on the tenant side, and now I primarily work with landlords. But I would say, I get questions a lot about, am I pro tenant or pro landlord? And I'm just pro doing the right thing. And so today we're going to talk a little bit about what to know if you're renting. And so we're going to start with the initial part of the most landlord tenant relationships, which is drafting a lease. And just so that folks know, I primarily work with residential clients, not with commercial properties. But, at its core, what is a lease? A lease is nothing more than a contract. It's the right of having possession to a property, and the right to have a tenant occupy that property in exchange for consideration. And usually that's going to be a dollar amount in terms of rent. So what does the lease require? There's statewide requirements that a lease must be in writing if the term of the lease is going to be longer than a year. or if the apartment has more than 12 units to it. So failure to have a written lease without, if you have either a lease that's longer for a year or more than 12 units, is technically a petty misdemeanor. I mean, it's not the most biggest criminal crime, but you could end up with fines for it. So, it's important to do the right thing. And written leases are usually better anyway, because then everybody's on the same page and we know what happens and what the expectations are at the beginning of a rental relationship, because usually that's when things are going to start off either on the right or wrong foot. So I recommend that oral leases are avoided whenever possible. It just creates a lot of confusion. And if you get into court, it's a lot easier to have a document that says this is what we're going to do. So the next questions that we generally get is, where can I find a lease and what leases should I use? Well, you can find a draft lease either on the Homeline website or on the Minnesota Bar Association. I've seen poorly written leases in my time at Homeline and in private practice. I avoid the internet at all costs because the internet didn't go to law school. And the internet is generally, even if you find a good lease, not Minnesota specific. And Minnesota has some pretty good tenant protections compared to some other states. So save yourself the time and money and get a lease that's compliant. And I would say that the State Bar Association does a pretty good job. Where landlords tend to get in trouble is when they start writing extra things in. And I would say the worst lease that I've ever seen, at my time at Homeline, I had a landlord who wrote a lease on a bar napkin. While probably legally sufficient because both parties signed it, it was not the best lease. It was a little corner. So in terms of, if you are going to have a written lease, we should talk about what provisions need to be included. What's important in your lease? Well, the first thing is the term of the lease. We should know how long the lease goes. Is it going to be for 6 months? Is it going to be for a year? Dates are usually important because you can sign a lease at a different time than when the lease starts. So having the dates in, say, from like January 1st to December 31st is usually a good idea. In terms of late fees have to be in writing. So if you want to charge your tenant late fees for not paying on time, that's common, but it can't be any more than 8% of the overdue rent. And so where I see a lot of landlords get into trouble is they just say it's 8% and then they calculate it off of the total rent payment when a tenant has maybe done partial payment. If your late fees are more than 8% of the overdue rent, you may end up not being able to collect them at all. So I have seen leases where it says, I'm going to charge a tenant $50 a day. Probably going to be illegal. So let's not put that in our leases and let's just have it, be compliant with the state law. In terms of caretakers, landlords get into trouble a lot of times because usually a caretaker arrangement is based on some sort of reduction in rent. And you say, okay, well, you're going to be my caretaker. So maybe instead of paying $1,000 a month, you only have to pay $600 a month. But we don't really know what's expected of the caretaker. We don't know what the terms of that agreement are, what their on-duty hours are, and what happens if you no longer want them to be your caretaker. I would say that the caretakers have to be in a conspicuous writing. So generally, it's a good idea to have a separate caretaker agreement, and you have to have it supported by adequate consideration. So generally speaking, you want to have kind of the responsibilities laid out and what the reduction is. If you don't do this and you end up in court and you have a fight over whether or not something was adequate or the writing was conspicuous enough, essentially what you probably have done is you've rented at a reduced rate for rent. So to avoid that, it's probably better to have a separate agreement and a separate writing. Additionally, where landlords tend to have problems, but it's an important provision, is in responsibilities for any utilities. We want to make sure that either you have a single meter or the utilities are apportioned properly in a lease. I've seen them where the landlords will say they'll pay for the 20% of kind of common areas to cover common areas and utilities, and then they apportion it by the remainder of the tenants. But this area does lend to some problems. Tenants do have a right to see copies of the bills, and they can request prior versions of those utilities. So you want to make sure that you keep records if you are going to be charging your tenants utilities and you have shared meters. And I think Mike joined on because he wanted to say something here.
Yeah, well, you got a question submitted here, Jess, and I'm going to jump in when they really fit what you're talking about on that actual slide. And this is a quick clarification question, but here's the question from Tammy, and you can have a drink of water while I ask it if you like too. So it gives you a chance to catch your breath.
Perfect.
So Tammy's question is that 8% of the rent or the amount that the tenant owes? For example, Section 8 public housing, that would be 8% of the tenant portion, not the full amount, correct?
Correct. So what I say is that, you know, generally with subsidized housing, you get regular routine payments and those come at the same time every month. And we'll talk a little bit about this as we get into some reasonable accommodations too for benefits, because not all benefits get paid on the first of the month, but it would be for the amount that the tenant owes. So generally speaking, like let's say in a market rate situation, you have $1,000 rent, right? Late fees would normally be $80. If the tenant say pays half, then the late fees would be $40 of that.
Okay, thank you.
Yep. And Tammy, I hope that answers your question. If not, please feel free to continue on and I will respond. I do like questions. They make me think and they let everybody here have additional information. So in terms of subletting, that's another area that gets to be really fuzzy. I don't particularly like it. Most leases will say that a landlord has to agree to a sublet. I think it's cleaner and it's easier to break the lease with the prior tenant and re-enter into a new lease with the new tenant. Technically, a sublet kind of creates a layered situation for landlords where the landlord does have the potential to go after the original tenant if the subletter doesn't pay rent. However, it can be hard to find that person. And then you end up evicting, you know, the person that you originally rented to. And there's a question of who's going to be responsible for what. So in terms of responsibilities, I prefer that if you are going to sublet, that you at least have a clause in there saying that you're going to approve the person subletting the unit, but it's generally cleaner to terminate the lease with the first tenant and enter into a new lease with the person subletting. The next thing that landlords want to include in their lease is the notice to terminate the lease. There's different ways landlords get into trouble with this. Either they have too long of a period. So generally you can't have more than what's called a 60-day notice or a 2-month notice. If your lease is silent, it's going to be a 30-day notice, but this is not a true 30 days or a true 60 days. It's a full rental period. So you want to be clear in your notice to terminate that they call it like a month and a day rule. If I were to give a landlord notice today to terminate a lease after the lease expires or it rolls to a month-to-month lease, then I would still owe December rent and I wouldn't be moving out till the end of December. If I had a 2-month requirement, then we'd be looking at January. The other ways that landlords get into trouble with this is they put in winter provisions because it's hard to find tenants in the winter. But this creates problems because you owe special notice if you don't want to accept a lease termination in the winter months. So you have to give that tenant an opportunity to properly break their lease prior to the termination not being accepted. So if you're not going to say accept a lease termination December through February, and you have a 2-month notice, then in October, you have to serve the tenant proper notice that you're not going to accept the break lease. And that's where a lot of landlords get into problems. So I think it's just cleaner to have a straight lease termination. And if you go to a month-to-month, you then have a notice period required. All notices must be in writing to be considered valid. And then finally, the other important provision to have in a lease is the right of reentry. And that becomes important for evictions because without that, you're going to have a heck of a time filing an eviction action. So you want to make sure that you have the right to get the property back. So now we're going to talk about some illegal provisions that we see in addition to the problematic ones. And a few of these include things like liquidated damages and assessing fines and penalties for things like making phone calls to the police or emergency assistance. That is strictly prohibited by law. A tenant has an absolute right to call the police for help. The other areas that we see a lot and that are common is that landlords say when you move out, you got to have your carpet professionally cleaned. Well, that's not true. They owe the apartment back to you in the condition that they rented it, less ordinary wear and tear. So those fees get you into trouble, and they're probably not going to be enforceable unless the tenant has damaged the property. And I see Mike back up.
Yep. Yeah. That's why you see me. Yeah, we got another question about the previous slide. We don't need to go back. We'll just ask the question. So they're wondering about the 30-day, month and a day, 60-day, 2 months and a day statement that you just made. So I'm just going to read the question and we'll try to figure the answer out. Does a 60-day notice requirement with nothing more run to the 60th calendar day following and require prorated rent for, the final month? Or does a 60-day notice end the lease at the end of the month containing the 60th day requiring a full rental payment? So maybe some examples of let's say we have a lease that has a 1 month notice requirement, a full rental period's notice requirement, and we'll just use today's date, November 16th. If you're the landlord and you want to give me a notice, how soon, my rent's due on the 1st, how soon can you make me go?
December 31st, if it's just a full rental period.
So it's not November 16th or December 16th that I'd have to go. It's December 31st. The end of that next rental period is what you're talking about.
Correct.
And so if we made that a 60-day rule, it would be the end of January, right?
January, correct.
Yeah.
Yep. Leases generally don't end in the middle of the month. And that gets really weird. And, again, I'm talking about residential leases. I've seen some weird things in commercial leases. So this is primarily for residential property owners.
Okay.
But yes, leases don't end in the middle.
Got it.
It gets rid of that weird, what's the pro rata share of rent problem too. So yeah. So then after the illegal lease provisions, we are going to start talking about how do we find good tenants and where should we advertise? I think that was one of the questions. And I kind of think that that's kind of specific to the type of tenants you're targeting and where you're going to be renting. But generally speaking, you want to be sure before you rent a unit, first of all, that it's compliant with all of the rental licensing and inspection requirements. When I was at Homeline, I had taken a few cases on, and one of the biggest problems was that landlords didn't have rental licenses. And what that meant is my tenant could get 100% of their rent back if the judge felt like doing that. Now, there might be an equity argument that you don't get to live somewhere for free, but when you don't have a unit that's compliant and you don't comply with the local licensing and you don't renew your license and get the inspections and things, you do run that risk of having essentially rented your place out for free, no matter how long the tenant has lived there. So it's really important that you work with the city, that you get in touch with, your specific city. They usually have a building inspector that will come out and do routine inspection, and you might be on a 1 year or a 3 year rotation, depending upon how long you've rented with that city. But again, if you fail to do so, you are also, not only are you responsible for and may be liable for returning all the rent, but you could be sued under Minnesota Consumer Fraud Act. And I think that was one of Mike's favorite cases that I had. I did that for one of our tenants, and the landlord didn't comply with the city. And unfortunately, they rented out a place they weren't lawfully able to rent. And not only was the landlord responsible, but the property management company was responsible in that case under the Consumer Fraud Act. In communicating with prospective tenants about the lease, you always want to be clear that you're not going to enter into a lease without a rental agreement, or be clear when those lease terms start. You don't want to have a situation where a tenant thinks that they have a right to be there, and They claim that you have locked them out or somehow wrongfully withheld the unit from them, because that can expose you to some liability. So I would say that best practices is to have a written lease and do background checks and explain to your tenants as you're showing a unit that you won't enter into a lease without a written agreement ahead of time. And then we get into the question of what screening fees can I charge and what should I do? Well, first you need to know that the unit's going to be available or will soon be available. I've had landlords who, thought that a tenant might give notice, but they weren't really sure. And it creates a lot of problems when you rent a unit and the prior tenant decides they're going to stay. So to avoid that, you want to know that the unit will actually be available. You actually got notice that they're going to leave. And then usually time to kind of clean and turn that unit over. You can always, for screening fees, obtain a consumer credit report or a tenant screening report. There are different agencies. I believe the state of Minnesota currently has about 9 different screening agencies. I don't particularly know that one's better than another per se. They all have different rates and different fees. But what you do have to do is you have to be clear with your tenant as to which agency you're going to use and the fees that are going to be charged, and the reasons why you are going to reject that tenant. So a landlord has to notify a tenant within 14 days of the criteria that the tenant failed to meet and why they're not going to rent to them. This can be orally done, but there's best practice again is always in writing. You don't want to have a question of whether or not you met your 14-day requirement or somebody got a voicemail or something like that. And in this case, I always say less is more. You don't want to accuse somebody of things. You don't necessarily want to get in a conversation or invite a back and forth about how horrible their criminal history is or how old it is or any of those sorts of things. It's just best practice to cite the criteria that you told the tenant they were going to be screened for and what they failed to meet. So if it's that they had an eviction in 2 years, you can just say, we use this tenant screening service. We found an eviction within the 2 years. And that's all you need to do. And so once we enter into the lease agreement and we get moving and we start renting, some common things that come up with tenants is that they're going to need repairs. A landlord is required by law to ensure that the unit is fit to live in, it's kept in reasonable repair during the terms of the lease, it complies with all the health and safety laws, and that it's reasonably energy efficient. You don't have to use the top tier like windows. You don't have to replace it with, $800, $1,000 windows, but it does, have to be reasonably kept, especially, Minnesota, it's getting cold. You don't want to have that draft. It drives up bills and things like that. Generally, what I see is the repair issues. There is no requirement that the repair must be in writing. The landlord has to respond to repair requests made by the tenant, regardless of the form. The question becomes how it's enforced. Okay, so, again, keep in mind too, Google's a thing. Google is real and tenants may review your property. And so, you want to do the best you can to be responsive to them. But failure to do repair requests can also have some dire consequences to landlords. The first type, there's 2 different types, and the first type of repair request is what's called an emergency tenant remedy action. These are for true emergencies. A tenant isn't required to give a written notice. They just have to give a 24-hour notice prior to the filing. So it could be a phone call, could be a call and a voicemail on your main property management line. But it applies to things like loss of water, heat, electricity, bathroom, or essentials type services. So you want to be very responsive to that. Tenants can get relief in terms of things like reduction of rent, not paying rent till the repair is made. You may have to put them up in a hotel. I'm not talking about a $300 a night luxury suite, but you might end up having to pay hotel costs for things if a tenant doesn't say have heat and the apartment drops below kind of a reasonable temperature. So you want to be very responsive to those types of requests. The second type of repair is a tenant remedy action. And this is where the written notice comes in and why people think that you always have to have a written notice. In order to file a tenant remedy action, the tenant has to have that 14-day written notice, and it could be a violation of anything, of any sort of health, building, safety, fire codes. It could be an issue with, things working intermittently, like sometimes the dishwasher might work and sometimes it doesn't, those sorts of things. The repair doesn't have to be completed within 14 days, but you do have to start making reasonable efforts. It might be that you can't get a fridge delivered within the 14 days. Shipping and things have been difficult. So, but you do want to communicate with your tenant so that you avoid that lawsuit and having like a withholding of rent, deduction in rent, or having a tenant be able to break their lease in the middle of it without any sort of penalty. The other types of requests that we get into are the reasonable accommodations. And these get fuzzy because it's not always clear. So a landlord has to make a reasonable accommodation for a tenant. It's kind of bending the rules or procedures or policies, but that has to be reasonable. And that can be a very kind of gray area in the law as to what's reasonable. I would say generally a change is reasonable if it's necessary, but it doesn't really impact the cost or a lot of money for the resources. And it doesn't really cause a fundamental change. It might be something like moving from a second floor to a first floor apartment that's available. It might be something like accepting rent on the 3rd of the month because that's when their government assistance comes in, and that goes back kind of that subsidized housing and things. A tenant can request a reasonable accommodation, and maybe it's acceptable to pay rent on the 3rd instead of the 1st. That's not a huge loss of income for a landlord to make that change. The real question becomes in issues of service animals versus companion animals. Service animals are limited. They have to be certified. Usually it's either a dog or a mini pony. So I always thought it'd be really fun to get like a little Sebastian in, and any Parks and Rec fan out there, the landlord has to allow the mini pony if it's a service animal. So you might want to allow that dog because it's probably a better option. Service animals are specific to the animal and they help with certain types of disability. So they might be there to detect a seizure, or they have a specific function. Whereas a companion animal can be anything. And while you do have to make reasonable accommodations, that accommodation still has to be reasonable. So if your lease says that you accept dogs that are under 25 pounds, maybe the accommodation is that you accept a small little Yorkie versus a huge German Shepherd. Now, if the tenant has a basis for having a larger dog, such as they need deep pressure or something like that, that a small dog might not be able to provide, then that accommodation might be reasonable. But you have to engage in that conversation. You owe your tenant that obligation. So if you have questions about that, usually it's a good idea to start getting in contact with an attorney so that you don't violate the Fair Housing Act. Landlords can request proof or verification of the need. Usually you're going to have problems if you start going into the specific disability itself, though. So it gets to be kind of a murky area. And I'd say if you find yourself in that position, you might want to gather some information from your tenant and contact an attorney and figure out what the reasonable accommodation should be and start negotiating that. I would say that there are huge penalties for that, and there are fines and attorney's fees associated with that case. So you may end up paying your tenant's attorney's fees in that situation.
Just not trying to drum up business for you, but it strikes me that even some of the questions landlords might ask would be a problem. So you said gathering information and then contacting an attorney. I think it might make some sense for a lot of landlords to
when I say
work on
gather
that
information,
before.
right. When I say gather information, get the nature of the request. Don't inquire into the disability, but ask what they're requesting and what they think is reasonable. So
and do you
when
do
you talk to an
trainings like that for landlords? Sort of disability discrimination focused trainings?
I don't do discrimination focused trainings for landlords. I have taken those sorts of cases on both sides. I think the attorney speaking yesterday brought up one of my more famous cases because there's different types of Fair Housing Act violations. So I've taken cases on the tenant side when a landlord installed a camera in the tenant's bathroom. It's a violation based on discrimination. I've taken them on the landlord side too, when, it just appears that there's nothing that is going to make that tenant happy, and they're trying to avoid paying rent, and they want to have, like, say 5 golden retrievers in their house. I love golden retrievers. I want one too, but it doesn't always mean that request is reasonable. It's really going to be fact dependent and situational dependent. So it's really hard to do a precise training on the reasonable accommodation itself because they are so fact dependent.
Sure. Yeah, I just would encourage landlords and their employees to kind of keep current on that concept, because whenever I talk to landlord groups, the one thing that they're most afraid of from a legal perspective is a discrimination suit, and a lot of them are going to be reasonable accommodation based.
It's where a lot of landlords get into trouble, and I hesitate to do like a broad training because I just feel like I'm going to miss something because every request is just so different.
Sure. All right.
So I do encourage you to find out what the accommodation request is. When I say gather information, thanks for that clarification, and then contact an attorney to determine whether or not that's going to be a reasonable request. Well, as like anything in a tenancy, all good things come to an end, right? There are different ways a tenancy can come to an end. Either the tenant or the landlord could give a notice of non-renewal. And again, in that case, I say less is more. You don't have to give the tenant a full explanation for why you're not renewing. Generally, that will invite a fight. You can just simply say, we're not going to renew your lease, and that is sufficient, assuming the lease is coming to an end. In terms of the tenant, the same thing. I mean, you might have had a long-term tenant and you didn't expect them to move, but they have a right to end that lease, and the lease ends when the lease ends. If a tenant breaks the lease prior to the expiration of a lease, that's generally where we see a lot of problems, right? And usually it's somebody fails to give adequate notice, or there's a dispute over whether or not you can continue collecting rent beyond the notice period. And I would say that while there's no specific law that says that you have to mitigate damages, many courts are going to require a landlord to attempt to mitigate their damages if a tenant prematurely breaks a lease. And like anything, right, if things aren't going well, you don't want an unhappy tenant living there. So negotiating it out and understanding the terms of breaking a lease are really important. And I would say routinely courts will grant you approximately 2 months worth of rent. What you cannot do is you cannot double collect rent. So let's say you tell the tenant, okay, well, I'll let you break the lease, but you're going to owe me 2 months worth of rent. If you call it rent and it's not a break lease fee, and there's no break lease fees in your original lease, and let's say you get this notice today, so you don't find a tenant by December 1st, you can collect December's rent, right? But let's say by January 1st, you find someone to move in, you're able to turn that unit over, you're not going to be permitted to double collect the rent. So you can't collect January's rent from the prior tenant and the new tenant in that situation. It can be harder to re-rent in the winter. So if you're going to, allow your tenant to break the lease and you say, well, you're going to owe ongoing rent until I can re-rent it, you want to make sure that you adequately document whatever efforts you are making to re-rent the property. I'd say generally most judges here in our area, I'm in Stearns County, generally want to see things like advertisements, posting, contacting a management company to try to rent it out for you. Some of those costs can be passed on to the tenant. And also, I would say even with that, usually you're only going to get about 2 months worth of rent if you end up in court fighting this out.
Question that came in about breaking the lease. Do you see courts require mitigation of rent damages despite precedent to the contrary? And they cite Grumman anonymously.
True attorney. Good job.
Yes, yeah.
Yes, I do. I would say I see a lot of things, and it might be different in the metro area. We do go into Ramsey and Hennepin occasionally, but I would say in rural areas, I see a lot of requirements to mitigate damages. And I see a lot of things like we were talking about illegal lease provisions. One of the things that landlords get in trouble with is having the tenant do lawn care or snow removal and things like that. And I find that less enforceable out in rural Minnesota, despite court precedent. I encourage you to still not do that and to follow the state law, because all it takes is the one judge to enforce it. So I'd say it's really specific. Those types of questions are specific to who you have as a judge on your case.
You see the duty to mitigate being essentially
Being a landlord's
created
responsibility.
in outstate greater Minnesota courts that you
Yes.
wouldn't see in metro area courts, is what you're saying.
Yes.
Okay, thanks.
So it tends to be very specific, and I think it's very judge specific too. And so if you get a new housing court judge, say in Hennepin, they might just say, well, usually litigants have an obligation to mitigate damages, so I'm going to require you to mitigate damages, and then it drags the fight out longer. But also, just because you can collect the rent as a landlord doesn't mean you're going to get it. You can always go back and sue for that back rent. So keep in mind that it might be an obligation under the lease, but at the end of the day, if you're enforcing that, you're essentially getting a piece of paper from the court that says the tenant owes it. It doesn't mean they're going to pay it. So that's a loss of income for landlords as well.
And I guess I should have maybe more clearly stated what duty to mitigate is. We have a really broad audience for these sessions. Some
Sure.
lawyers are watching, some landlords, some tenants, social workers, city officials, things like that. So duty to mitigate, the concept here is the landlord has to, if the tenant breaks their lease, the landlord has to try to re-rent the place. That's what we call a duty to mitigate, to keep their costs down based on a breach of a contract. And Minnesota is one of, I think it's still 7 states that does not have on its either a court case at the Supreme Court level or a statute that says that the landlord or somebody like that has a duty to mitigate. And that's about an 80-year-old case. And so that's why it's a fair question to ask. And it's also a fair question to wonder, should a judge do that or not? Should they make a landlord mitigate their losses, or at least try, or not? And under case law in Minnesota, probably not. But as Jess has just pointed out, judges sometimes sort of do what they think seems fair versus maybe what the law might be saying it should do. But anyhow, I'll let you get on with the next topic.
Oh, that's all right. I also do appellate work. I have yet to see the Court of Appeals pick that case up, so can't give you a good answer. The law school answer for those attorneys out there is it depends. So when things end really badly, they end really badly. So one way a tenancy can end really badly is through eviction court. So it's the only forcible way to forcibly remove an unwilling tenant, whether it be unwilling to pay rent or unwilling to leave after a notice to vacate. If you try some self-help, and some have to the extreme, it could be things like shutting off utilities or shutting off, access or changing the locks, whatever it is, and that tenant has a right to be there, meaning you haven't filed for an eviction, you could be responsible. It's a minimum of $500, and it could be up to triple damages. So if you lock a tenant out and they stay in a hotel for a week, you might owe triple the hotel bill. So it is an expensive thing to do on your own. Even though eviction is an expensive process, it's important to do it and follow the rules correctly. So what does that mean? Well, again, in Ramsey and Hennepin, they used to have rules, and I don't know if things have changed. I've heard different things, so I'll let Mike answer that. But out in greater Minnesota, if you are a corporation, meaning or a partnership or a LLC type thing, you're not a private person, you have to have an attorney represent you in court. A landlord has to have the tenant served properly, and there are service requirements, and it has to be 2 temps of personal service. And then you have to mail, then you can mail and post it. Everybody talks about it as kind of a nail and mail shorthand. But if you don't follow those procedures properly and you don't follow the service rules, your eviction could be dismissed. Service is strict compliance. So if you do not follow the rules appropriately, again, the tenant can dismiss the eviction case and you end up starting all over. At the very least, the final part of that service, whether it be personal service or posting, that has to be done 7 days prior to the eviction hearing. So again, that personal service has to be attempted before you can mail it and then post it. One of you have to try personal service on 2 separate days, and one of those has to be between the hours of 6 and 10 p.m. So the other thing that we get a lot is, I have an emergency and I need this tenant out immediately. And they request an expedited eviction. It seems to be more common now that kind of post-COVID is hit, but the courts are still processing all those COVID cases when we couldn't evict. I would say in Stearns County, it takes about 30 to 45 days to get a hearing date. In terms of an expedited eviction, they're rarely used, they're rarely granted, and I would really talk to an attorney about that, because the court can impose a civil penalty against you if they determine that your case is not urgent or in need of expedited relief.
And those are
So,
only for the drug cases, the
cases,
illegal
yeah.
weapons, things like that, right?
Yep. Yeah. So, and I know that we gotten a question about kind of some of the crime-free, drug-free stuff that was submitted. There was a question about, I think, a blanket provision, and there is some guidance on whether or not, in terms of the background check, it should be permitted to have a blanket prohibition. But I will say, once you're renting, you have, as a landlord, you can't allow drugs on your property. So those can be expedited. Okay.
I think
But
the
it's
question you were, I'm sorry, Jess, I think the question you were asking or mentioning there was one that was pre-submitted. And I'll just ask it directly right now.
Yeah.
And I think it's for it is for applications. Are blanket bans for applicants on, quote, all drug felonies within fair housing guidelines? So I think the landlord wants to say no drug felonies and just not even look past that. If that hurdle exists, it's not a hurdle, it's a full block.
And I would say there's mixed reviews on that. So again, that's why I kind of differentiated. This is after you're in the lease for that expedited eviction. You can't continue to allow drug use. In terms of the screening, there is guidance put out by the Fair Housing, and there have been suggestions that we shouldn't do that, especially as, things like marijuana, you can get charged as a felony. And, those blanket provisions prohibit people from getting access to housing. But I would say few courts actually say that, it's an outright ban, or, they disagree. They think that you can ban people for having used drugs in the past and been charged with a felony. So there's kind of some mixed reviews. There's not a clear line in terms of the screening process. There is a clear line in terms of the eviction process. So in terms of the eviction hearing, when you go to court, generally that first hearing is rarely a trial, or what they call an evidentiary hearing, where you're giving testimony. Usually that first hearing is determine whether or not there's a basis to set a trial. If you're evicting a tenant for something like non-payment of rent, they're going to be required to bond over for trial, and that bond is the amount that they owe for rent plus the accruing rent, and generally the court fees. If you are evicting a tenant for kind of two things, let's say they both did not pay their rent and they are breaching the lease. They're parking illegally or something in the lot, they're doing other things. If you allege both, then there isn't that same bond requirement for the breach of lease as there is for just a non-payment of rent case. So really that first hearing is set up to determine whether or not we're going to have to go to a trial. That I would find that most judges post-COVID are going to ask if you want to offer a settlement agreement. The court will give the tenant generally an opportunity to do what's called pay and stay during that period, so they could pay the full amount of rent plus the court fees. Attorney's fees are capped at $5 at that point. For the redemption, it doesn't mean you can't go collect them under the contract later, but the redemption the attorney's fees will be capped at $5. And the tenant can redeem, and the court will give them up to 7 days to do so. I've seen some judges, do it as short as 2, and I've seen that same judge do it 7 days for like a hardship where they have, like, say, a young infant or something, and it's harder for that family to move. So just be prepared that that first hearing, if they come with all the rent and things, they may be able to stay. The eviction will still remain on their record. If things end well and the lease just naturally ends, then we're starting to look at what happens with the security deposit. Well, a landlord owes the tenant a written statement as to why they're going to keep the deposit or why their deposit is being withheld. And there's only certain reasons why that deposit can be withheld. And it could be things like non-payment of rent or owes for utilities. There were damages upon move out, but otherwise you have to return the deposit with interest, which is currently 1% per year. And Homeland has a nice little worksheet for you. It's a flat rate. It's not compounding interest. So for those of us who went to law school, so we didn't have to do math, the math isn't hard. But if you don't either provide a written explanation or return that security deposit to the tenant, then you could be liable for twice the amount of the security deposit and the interest, plus a civil penalty for up to $500 of bad faith. And I have had judges award that $500. So it's really important to document why you are keeping that deposit, because if you go to court, you need to be able to show that the place was somehow damaged and it was beyond the ordinary use. Now, everything has a life to it. And I think it's a common question for landlords as to, what is necessary and what is ordinary wear and tear. Well, there's anticipated lifespans, and I kind of gathered these from a few different websites and just kind of general practice experience, but general standard rental grade carpet has a lifespan and will need to be replaced within 5 to 7 years. Additionally, paint has a lifespan of about 3 to 5 years, and vinyl flooring about 10 to 15 years. So keep that in mind when, if you haven't replaced the carpet, let's say, and it's been there for 3 years, and then you have another tenant who moves in and they stay for another 4 years, well, that carpet's probably going to have to be replaced anyway. And aside from, spilling bright red wine or something down white carpet, a court's probably not going to award you damages for the carpet. Additionally, we get into trouble with the charges and the amount withheld. And so my favorite case is I'd seen a pro se landlord try to sue on a security deposit, and he kept telling the judge that his cleaning rates were $250 an hour. And he had done the work himself. And I would say that when you do the work yourself, most courts are going to limit you to about $25 an hour. But the landlord was persistent. I'll give him that. Mad props. And he kept arguing with the judge and said, well, ServPro charges $250 an hour. So I'm going to charge $250 an hour. And I would say you're generally not going to get that. Also, in calculating the damages, you're going to get the replacement value. It's not going to generally be that brand new cost if you go into court. So if you're talking about damage to a stove, it's kind of that value of the 3-year-old stove and not a brand new stove per se. So I saw Mike jump in here, so I think he might have a question.
Couple specific questions. First of all, your old friend Patty has a question.
Hi, Patty.
Which is, she says, do you have a resource for these, quote, lifespans, end quote? And so maybe you could send those on when you have a moment.
Yeah, they were kind of compiled. They were an average of different websites. So I can go back through and find the websites, but I did kind of an average. I checked a few different ones, and I can send those on. Absolutely.
And Patty, of course, says hello back. Another question from Heather. I don't think I've ever heard this question before, if I'm understanding it right. I think Heather is a landlord, and she's asking, can you pay the tenants that 1% a year if they stay? I have tenants that have stayed 2 to 3 years, and I just paid them in January. So I think this landlord is saying, I'm giving you your 1% interest each year as kind of a anniversary present of our tenancy. I've never heard of a landlord doing that before.
I haven't either. So that was really nice of you, Heather. Congratulations. You win Landlord of the Day. You get bragging rights, I think. If you returned it and you have documentation of it, I think a court would be inclined to say that you did return that interest, but I'd be very clear in returning that that is the interest on the security deposit. I guess I practice in family law also. So, you know, if y'all have family issues, I do that sort of stuff too. And I kind of liken it to voluntarily paying child support, right? Like the court can order child support. You can look back for 2 years on child support. It's super fun. But sometimes I get people who voluntarily pay for things and they think that that's child support. So I'd be really clear about what we're paying so that if you end up in court and you're arguing about a security deposit, and you say, but I gave that 1% back. You don't want the court treating that as a gift. You want them treating it as the interest payment. So I'd be clear in documenting and making sure your tenant knows that that's what they're getting.
Yeah, it's sort of a bygone era, but when I started back in the mid 90s, it wasn't that uncommon for landlords to give some sort of gift card or gift certificate. I guess gift cards didn't exist back then. Saying, hey, you've been a tenant for a year, happy holidays or whatever. Here's $25 or $50. That doesn't happen I don't hear about that as much, but you'd want to make sure that 1% isn't seen as just a gift, but is actually the payment of the interest is what you're saying.
Yeah.
Interesting approach. Yeah.
That was really nice. That's a new one. I learn something new every time I do this. So that's great. Thank you. Then we get into, well, people have left. And so now what? Because they've left stuff behind and I don't know what to do with it. Well, a landlord has to store the personal property that's left behind by a tenant. And some of the rules are kind of governed depending upon how the tenant leaves. But you can charge your tenant moving, storage, care costs, that sort of stuff. If a sheriff comes out and inventories it, I believe there is a cost for that too. All of that stuff can be part of the charges. Outside of a writ of recovery and an eviction sort of situation, you can't hold that property hostage though for those fees. So I would be really clear in documenting kind of what you kept and how you kept it. After 28 days, especially in eviction cases and things, you can consider the property abandoned. But if you are going to somehow repurpose that property and try to say, I don't know, recover some rent charges or things like that, you have to give your tenant notice. And that notice is 14 days in writing of your intent to dispose or sell of that property. So I would just be really clear. It's good practice to do everything in writing and give that proper notice of what you intend to do with their property. Also, as an aside, that notice is accomplished by first-class mail and certified mail. So people kind of get confused about the certified mail thing, I think now, because the internet is more common. So let's not do emails, but let's follow the rules. First-class mail, it's always going to be presumed that the post office is going to get the delivery correct, but one way that you can confirm and show that the post office actually delivered it and avoid that fight is ask the post office for delivery confirmation on that first class mail. It's a little bit of an extra fee, but it tends to be worth it in terms of, especially if the tenant's going to fight you at the end of the day. The certified mail, the tenant actually has to sign for it. And so the requirement is notice is accomplished by both. But you can ask for first class mail and delivery confirmation, and that's to their last known address. So I guess going back to that security deposit and the abandoned property and all of that sort of stuff, that 21 days, just as an aside, starts from when the tenant gives you a forwarding address. If you know a tenant's going to move, it's usually good practice to just ask for that address because sometimes they don't give it, but then you know where to send mail. Sometimes they don't like giving you their new address, but it can be any place where the tenant can receive mail, and just keep that as part of your file and your documents on that tenant file. So I guess from here, I have said kind of everything that I think I had in my presentation. I know there were a few questions submitted, and I'll open it up to questions.
Oh, there's a lot of questions that we have filed.
Oh boy.
This has always been my favorite part of these meetings because you don't really have as much control over what you're going to do. But before we do that, Jess, just give us a quick ad. What kind of work do you do for landlords? Who should be thinking about hiring you or somebody like you?
Sure. So I do work for generally landlords because tenants can't afford me. Again, I'm pro doing the right thing. But I do all sorts of things. I do evictions, I will do repair defenses, I do lockout defenses, security deposits. I also do things like lease reviews. So if you have questions about your lease and you're thinking about getting one of those Minnesota multi-housing leases, and they have sections where you can write things in and you have questions about should I or shouldn't I do that on a flat fee service. So I do lease reviews, or I'll help you draft a lease that is compliant. So
Yeah, I remember my first day of law school in property class, the professor said, here's some career advice. Always let your clients draft their own lease because it'll be 3 times the work for you later.
yes.
Yeah. So the converse is, it'd be better to talk to somebody like Jess before you have a lease that you present to a tenant than after and say, hey, wasn't my lease good enough that I found online? But yeah, let's dive in with some questions if we're ready. Yeah.
And I'm going to jump in here and start asking questions because some of these are going to be for Jess and some of these will be for Mike. And I'm sure you both will have opinions about the other's answers. So feel free to have feel free to jump in as well. We're going to start with the pre-submitted questions first, just because they were pre-submitted. And then we will dive into and get through as many as we can of the ones that were submitted during the presentation. So, and also thank you so much, Jess, for all of this. This is great, super helpful information.
And it is very obvious, what you're talking about here. This is really useful. Yes.
Yeah. And this is being recorded and we will be posting it to our website. And for those attorneys out there, we are going to be applying for CLE credit. So, all right, let's jump in here. So Peggy has actually, they are a landlord or property manager, and they are asking something very similar to what we were just talking about. How does one reclaim possession of a property that the tenant has abandoned but is still under contract to pay rent? I don't know exactly what Peggy is trying to say.
Well, I think I know this one. I think that I know the question at least, which is, the tenant's gone, they still owe rent. How do I reclaim possession if they've basically abandoned the property? Do I need to go file an eviction? This is a pretty common question at landlord speeches. Do I need to file an eviction if the tenant's clearly abandoned, but the lease is going on, that kind of thing?
I generally recommend it for a couple of reasons. It clears it out, so there's no question as to who has ownership of that property. You don't want to have a tenant come back and you think, oh gosh, they've been gone. They've abandoned it, and you find out that they were taking care of, I don't know, I'll call her Grandma Thelma or something. I'm trying to think of a good grandma name. Grandma Helen. Grandma Helen got sick or something, and turns out that the tenant left the state for a couple of months. You think it's abandoned and you happen to be wrong. If they owe rent, you can file an eviction the moment that rent is due and they haven't turned over possession. So if the lease is still ongoing, I do recommend filing that eviction just to make it very clear that you could re-rent it in the future. You don't run that risk of making a mistake and finding out that they didn't actually abandon the property, because those are fun questions and not so fun fact fights. And so just to be clear, if the lease is still going on, you have every right to file that eviction and clear out the property. It shortens the deadlines for getting the property back to the tenant in terms of following the eviction statute versus an abandoned property statute. If they've turned over possession and the keys and they've just left things behind, then you follow the abandoned property statute.
And the only thing I'd add is I think it's in both parties' best interest if an eviction is not filed. And so if I'm in the landlord's shoes, I would do everything I possibly could to communicate with the tenant. You'd text, you'd email, you'd write, you'd leave a note under the door saying, hey, we haven't gotten paid. It looks like you've abandoned. We don't want to file an eviction. If you give me something in writing, giving up possession and return the keys, I won't have to. And then an eviction won't be on your record, and it'll save me $300 for filing, plus maybe hiring an attorney. So nobody really wants the eviction there. I think you're probably right. If you can't find the tenant, you can't reach them, you kind of have to do the eviction, is the most conservative answer. I think that's right.
Okay. So Heather is a landlord, has a 2-part question. One you covered fairly thoroughly. Can we still charge up to 8% late fee? And then also how to enforce lease clauses for extra guests being there too much and adding them to the lease.
So a couple of things, right? Like guests get tricky because if you don't have something in your rules that say, a guest is someone who's been here for 7 days or 14 days or whatever, I would say the rule of thumb is somebody who stayed longer than 14 days, you might want to start looking at adding them to a lease. But if you don't have something, too long can be kind of a subjective term. So I've seen some fact fights over that. If you have, if somebody's been there for a couple of months, clearly you probably want to then add them to the lease. Also, you can get into trouble if you've accepted rent and you've known that that guest has been there for what you consider to be too long. You may have waived that breach of lease. So I think, it kind of depends upon how long that guest has been there. But if you're looking at having problems, I think that the first thing that you do is kind of what Mike suggested with the first question, and reach out to the tenant and say, look, I know we've been accepting rent. I know you've had a guest there for now, say, for example, 2 to 3 months. I'm no longer allowing this person to stay here without being on the lease. And then you could do the background check and add them to the lease.
I think if a landlord does admit that in a letter, they probably need to give some sort of notice of enforcing the breach violation, saying, hey, because you're sort of admitting, I know that they're living there. And I've been accepting the rent knowing that. So starting January 1st, if they gave the notice now, I'm going to go file an eviction for breach of the lease because I'm not going to allow that breach to go on, that continuing breach. Yeah.
Sure.
All right.
Fabulous. Moving on, Kelly, who is a service writer, is asking, can you explain why it would not be in the landlord's interest to accept payments from the tenant after an eviction has been filed?
Well, it kind of depends a little bit, and I'm not sure the history of this landlord and tenant. But, and again, I think best practices, again, is giving that notice of the breach of lease. But if you have a tenant who has made partial payments in the past, sometimes you could waive that right to demand the full rent by having those partial payments and having kind of a pattern and practice of accepting partial payments.
And Jess, I'm not sure if you have the question in front of you, but it was after the eviction was filed.
Oh, okay.
Partial payment after the eviction. Yeah.
Yeah. And you don't want to get in a situation where you're kind of then looking like you've accepted this as a settlement offer without getting the full payment. If the eviction's already been filed, you want to have very clear that you're demanding that full rent payment, that this isn't somehow creating a new right to stay.
Yes. So Sandra is a tenant and they are asking, what can I do about toxic chemicals in my apartment from drug manufacturer? Both management and police ignore the problem.
Yeah, I'll take this one. Yeah, this is going to be probably, it's going to be a hard case because you're going to need to have some sort of evidence. But you could do a rent escrow where the tenant actually says, landlord, it's your responsibility to provide a place that's habitable. And because of this drug manufacturing that's going on, that's not the case. And so I need you to solve it. You don't have a contract with the neighbor who might be manufacturing the drugs. You do have a contract with the landlord. And so that's who you have to say, hey, hold up your end of the contract. So a rent escrow might be the easiest thing to try to do. And it's pretty user friendly. It's the same price as small claims court for a tenant to file one of those cases.
Perfect. All right. Harlan is a tenant, I believe, and they just put in about citywide apartment inspections. I don't, Mike, if you could talk briefly about just city inspections in general.
Harlan actually submitted several questions and cited a court case too, Baker versus City of Portsmouth. And Jess, you actually wrote an amicus brief for the Golden Valley Weebsick?
Yep.
Am I saying that name right?
In the city of Golden Valley. I wrote both to the Court of Appeals and the Supreme Court.
The state Supreme Court, yeah. There is a lot of case law on city inspections, what's allowable, what's not allowable, when can it be mandatory, when it can't be mandatory. We're not going to go into the whole case history of are inspections legal or not. In general, city inspections, first of all, not every city has inspectors, not every city has an inspections department. Where they'll send inspectors out. But in general, most metro area, and I don't mean just Minneapolis and St. Paul, but places like St. Cloud, Duluth, Rochester, will have inspectors as well. There tend to be two types of inspection systems. One is a complaint driven, where the tenant calls up and says, hey, inspector, I got a problem, please come out and have a look. The other are kind of routine, every 2 or 3 year checkups, where it's not complaint driven. The city just says, hey, we're going to look at apartment number 3 this time because we're doing random inspections or these routine inspections. And so it's an important part of the landlord tenant equation when it comes to habitability.
Okay. Perfect. All right, I'm going to move on to the, we got several questions from someone at Ernest Lee Property Management. So one is about removing amenities due to overuse per my lease. And the best ways to document tenant behavior if an eviction is needed, and best ways to advertise and recruit good rental candidates. So you covered the third one pretty well already, but if you've got any suggestions about waste, essentially is the, kind of the legal term that I think of when I read about overuse of amenities, but potentially, like, I don't know, hogging the hot tub at all hours of the day and not letting other people use it could be something along those lines, or best ways to document tenant lease breaches or something like that.
And I will distinguish this too from commercial leases, because I have seen commercial leases where, so I don't know what kind of property management this is, where if the tenant does commit waste or overuse a common space or encroach upon, like, say, a patio space of another tenant or things like that, they reserve the right to remove the patio with like certain notices. Or they might say, if you own a bar but you overuse the water or something like that. Those are very different than residential leases. I would say a residential lease generally is going to fall within the 4 corners. And then outside of that lease agreement, if somebody is committing waste, you need to be able to attribute it to that specific tenant. So I'm not quite sure what the waste is. If you're talking about like people in the hot tub at all hours and you're getting neighbor complaints, that might be a breach of lease sort of issue. And maybe it's a lease violation and notice you'll want to document it. If you end up in court, you're probably going to have to call those neighbors as witnesses and the people who have seen them and been told to, like, they can't use the pool or the hot tub. I get really sad when I can't use my hot tub, but you're going to need to have some proof of that. If you're talking about waste like utilities, you're going to have to be able to know which unit that's coming from. And generally that is, going to be hard in a multi-unit situation versus a single meter. So I'm kind of
going to
more
jump
of a
in because we have more details about this specific question now.
Okay.
Isha said, I sent the question, it's overuse of washing services. So we've heard this one before. Laundry, maybe somebody's turned their free laundry on the, second floor of the apartment building into all their friends' free laundry. We'll just assume for a second. So they're doing laundry for people and not, or maybe they're charging them for it even. Let's just make some facts up here. So I think a solution might be for the landlord to maybe set up a kind of a nanny cam in the laundry, right? That's a public area.
Yeah.
That's not a private space that somebody's renting. So they could figure out who it is that's coming in again and again, I suppose.
Yeah, but you're going to need some documentation of, kind of big question for the court is going to be, especially with a common area type thing, is, how do you know it's that person? So something, as Mike suggested, then a camera is very useful and they're relatively inexpensive. You can get them a fairly good quality camera at like a Best Buy or Amazon or whatever. So.
All right, let's move on.
Perfect. All right. Mike Sang is an advocate and they're wondering about breaking a lease. That's, I think, both of you, I think it would be very helpful if you have some general pointers from both perspectives for landlords and tenants of what is, if it's in your best interest to break a lease or what that looks like for a good break lease situation for both parties.
Yeah, I mean, there's some things where a tenant can say, I want to break my lease and you have to let me, but they're pretty rare and they don't come up very often. Domestic abuse, you're in the military, you get called up or transferred to the place becomes completely unlivable because of really bad conditions, like there's a fire or a flood. But general rule, we're talking about a contract here. and a tenant says, I want to get out of my lease, the first thing we always ask on our tenant hotline is why? Why do you want to get out of your lease? And they go through the explanation. Usually it's, I got a job somewhere else, or I lost my job, or I'm going to move back home with somebody who's sick, or I've got a romantic partner and I want to move in with them. None of those reasons get a tenant out of a lease. They just don't, unless the lease happens to have some language like maybe buying a house. Some rarer everyday leases say if you're buying a house, then you have the right to break the contract with some sort of penalty. So breaking a contract is really hard to do. It just is. There is kind of this concept of just sort of looking at the market, though, which is if the landlord has 100 people that really want to move in, breaking a lease might not be that big a deal to them. And so it's just a matter of communicating with the landlord. If they don't have 100 people waiting to move in fact, they have 10 empty units, they're going to fight to not let the tenant break the contract. So sometimes it's negotiable, sometimes it's covered in the lease itself, but it's the kind of thing that it is very fact specific, and we generally want to talk to a tenant if they're trying to get out of a lease.
And I guess in that same vein, I kind of look at it this way too. And when I talk to landlords is, look, it's not prison, right? Like you can't make somebody live there. If you want to be sure that you're going to get some money and you don't have to try to find them later and track them down, it might be a good idea to negotiate what those terms are. As Mike said, maybe there's only, 100 people waiting out the doors. Well, maybe you can charge more rent for the new, turnover of the lease. It might be advantageous. If you don't have anybody and you have 10 units, well, some money is better than zero money. And if your tenant's going to leave anyway, or you have somebody who's generally unhappy, are they going to treat your property well? Probably not. So let's figure out what those terms are and see what is in everybody's best interest to break that lease. And I will say too, because I read the word advocate on the question or whatever, and my mind automatically goes to a domestic violence advocate, just in the nature of my work. The statute is very specific on how you give that notice. So if you're going to do that, you need to follow the rules and have everything in that notice the way that the statute defines. And the tenant's probably going to forfeit that security deposit, and they also have to be current on rent. So just be aware of why that break lease is happening.
I'm going to skip one to Tiffany, who's a landlord who has a question that we have been batting around here at Homeline for a little bit of what to do if presented. I'm assuming a tenant is presented a non-renewal following an eviction being filed. So say, especially in the metro counties, a landlord has filed an eviction for non-payment of rent, say in October, but the hearing isn't scheduled until December. And so they also give the tenant a non-renewal notice after the eviction's filed, but before the hearing date may happen.
I think that's tricky.
That's why we've been having
I'm
some
with you
discussions.
Right, because look, if the tenant wins the eviction, right? Like let's say that they have a rent escrow action going at the same time, and those cases have to be heard together, and they've asserted those rights, then you run the risk of giving a notice during and having it be considered retaliatory. Without knowing more information, that's really hard to say. And it, on the flip side, it feels kind of duplicative, right? Like if the landlord has a hearing for an eviction, and let's say the landlord's going to win the eviction and gives the notice. I mean, there's no harm in necessarily giving that notice if your tenant is for certain going to be evicted, right? Like maybe they leave faster. I don't know. But also I think that there's some risk in there. That if they're filing a rent escrow or they're claiming repairs to offset rent and they're right, you run the risk of having that notice being retaliatory and not enforceable.
Yeah, and to some degree, this is going to be a moot question fairly soon, because this really long time where evictions are filed and cases are held off for months is not going to last forever. The old system is evictions were 20 to 30 days from the day the landlord filed the case to the day the tenant had to go. And that's true still in many parts of the state. In fact, most parts of the state, but in the core counties, they just haven't caught up yet with some post-COVID court catch-up stuff. And we've had a lot of evictions this year, more than any other year. So,
Yeah, and it's hard on both sides. I've seen
It is.
landlords who had to hold off on filing, and they were owed $16,000 in rent, and they just want to start being able to re-rent the property and that sort of thing. I get it, but also, I just think that, as Mike said, the courts are now starting to catch up. Things have changed. We're not going to say that COVID wasn't a thing and that people didn't have hardships, and you shouldn't have worked with your tenants through those hardships and things. But also, I think I just filed an eviction in Stearns County the other day, and it used to be about a 60-day waiting period before I could even get a court date. And I think my most recent one is now about 45. So things are moving and processing.
We had two other questions that were pre-submitted. They're more tenant specific situations. So in general, I would definitely recommend contacting Homeline directly. If you are a tenant, you've got a specific situation that you have questions about, our information is here on the screen. Again, we've got phone lines in multiple languages, and as well as email. And frankly, we have a lot of resources just on our website that you can also look through as well at homelinemn.org. I'm going to move over to some of the questions that were submitted during the presentation. So one is about, Kelly is asking a question I think really boils down to expungement, right? Is a landlord able to ask for an expungement? In this case, it was that the payment was made before the hearing happened, and so the landlord dismissed the eviction case, but that means that the tenant has now had to file for an expungement as opposed to being able to ask for it during the hearing. Is that something that is the tenant able to ask the landlord to make the expungement request, or is that something that the tenant can ask the court to do beforehand? I think that's what Kelly's getting towards.
So I've done expungement work. I know Mike probably has gotten it on the tenant hotline. I would say it depends upon your judge and the basis for it. I've seen more so in the metro and in Hennepin County, Ramsey County, where the judges might do it during the same hearing. I would say out here, the judges treat it as the tenant's responsibility, and that they make it a little bit more difficult for expungement. And I haven't seen it granted during the hearing. And even when I've had landlords settle for things like not opposing the motion to expunge, the judge has been very clear in outstate Minnesota that it's not automatic.
Yeah, so expungements are complicated in a couple ways, but these are court records we're talking about, and courts get very territorial about that kind of thing, or they can be, maybe justifiably so. But there's two ways to really get an expungement. One is for the court to say, you know what, these are court records, I get to do whatever I want with them, which is one time what you'll kind of hear from a judge, maybe that exact phrase. But there's also some statutory instruction when it comes to expungement. And if you're going with the statutory version of an expungement versus the court authority, that does say that it's got to be initiated by the tenant on the statute itself. Now, that's potentially going to be reworked this year, along with many other landlord tenant laws. We're not sure, but as it sits, the tenant's the only one who can actually make a motion under the statute to do it. They can always ask for the court authority to do it, and it usually makes sense for the tenant to ask for both. But
I would say in terms of the expungement, it's more meaningful to do the statutory expungement than have the court authority, because then it expunges a greater amount of records and a greater amount of filings.
All right, thank you. All right, next we've got, let's go. So Jasmine asked a couple of different questions related to landlords' responsibilities for pest infestations, and whether someone can terminate a lease for that, and whether they are going to continue to be responsible for rent if they do under those circumstances.
So some of that is going to depend upon the lease in terms of the responsibility and the eviction and things like that. A lot of leases, it's common to say that a tenant is responsible for rent even after an eviction, that they'll be responsible for the ongoing rent till it's re-rented. I think that there's probably more duty to mitigate in those situations than just terminating a lease in the middle. In terms of infestation and responsibility, you're going to run into some habitability problems on the landlord side. Where I see problems are things like, we turn this place over and it's clear of, say, bed bugs, right? And then bed bugs show up and the landlord says, well, I'm going to automatically assess you the bed bug fee, but they don't necessarily know how the bed bugs came in, if it's from you or a neighbor or those sorts of things. There are other situations where it's more clear and you have photos and the tenant looks like they belong in an episode of Hoarders, and you can't make your way to the door and there's been food left out and you can see, you know, maggots and stuff on top of that food. I think then you're going to have a more clear line that that's going to be the tenant's responsibility and a breach of lease. And I've seen everything in between. So without more, you know, it's going to be fact dependent.
Okay. Peggy, along a similar line, I had a couple of questions about determining who determines whether a repair needs to be done if the space is unhealthy. Like, who determines that?
Some of it is going to be determined by city code. There are some city and, you know, requirements and things, and that's part of those rental inspections and things like that. If it's clearly a violation of the city code, I say you're going to have problems. I think our friend Patty has had the flip side where, you know, there was just not making that tenant happy. And there's a difference between kind of making someone happy, and you can kind of tell by the amount of repair requests. You know, if you have somebody who sends a repair request in month 1, and let's say, you know, you're the landlord and you get the repair request today, like, you should probably address it and see if you can take care of it, right? But then all of a sudden on December 16th, you get a repair request for something else. And then on January 16th, we get a new repair request for another single item. And this goes on through, say, December of the following year. I mean, there are certain things that are just kind of cosmetic, right? And maybe not super important. And there are other things where it goes to the habitability. And I would say you have to address those things that go to habitability and things like that. And, you know, there might be questions about who's causing the damage or how the damage happened. But I think that at a certain point, you can get to a point where, you know, it's just not reasonable anymore.
Right. We have about 5 minutes left. So I don't think we're going to get through all of the questions here. So I'll try and make sure that we get some of the ones that haven't been covered throughout. Isha did want to know, for a reasonable accommodation request, does a tenant need to make that prior to moving in?
No, it can happen at any time during the lease.
Okay.
People's health and conditions change and they may not know it prior to the move-in.
And Rachel, I can stick around for 15
Okay.
extra minutes. I'm not sure about Jess's schedule, but I can answer whatever I can.
Absolutely. Okay. So yeah, we can stick around and try and get through. Jess, if you're able to stick around, awesome. If you're not, again, thank you so much for all
I'll
of
stick
your
around for a little bit more.
Okay.
awesome. Thank you.
Yeah.
All right.
We'll pay double your rate, Jess, for overtime.
Awesome. I'm
It's coming
looking
out of
forward
your
to that.
pay.
I get paid in coffee, by the way, too. I do accept coffee payment.
Yeah.
Fabulous. That we can help with. All right. Sherry is wondering, if a client is receiving housing assistance from an agency and the landlord is required to sign a contract with that agency as well, would it be wise to have the contract added to the landlord's lease so that all 3 parties need to sign that lease?
Subsidized housing gets tricky, and I think it depends kind of on the type, right? Like, there are certain things that are project-based, there are certain things that are voucher-based, and typically the way that I have seen it done, and again, I've seen it where the tenant enters into the agreement with the housing authority, like say Section 8, right? Like, they enter a contract with Section 8 and they say they're going to be lease compliant, they're not going to get evictions, they're not going to use drugs on the property, and they have certain Section 8 rules that they agree to. The landlord and Section 8 also have a contract together, right? And they say, okay, well, we'll accept your voucher and we'll, keep the place. You have a right to come in and inspect it as, Section 8, and we'll meet your requirements. And then there's the agreement as between the landlord and the tenant for the regular rental terms, right? Like, things like guests, late fees, breaking leases, those sorts of things, right? I would say that, if as a landlord side, it might be wise to say that, as part of your lease, you'll comply with the requirements from the housing authority, and you'll comply with those conditions. But I think you're going to have a hard time adopting it as your own because you're not the agency. You're not Section 8.
Thank you. So Anonymous is wondering, if a landlord files an eviction against a tenant and the tenant vacates the unit, can the landlord still try and charge the next month's rent under the claim that the tenant did not give adequate notice?
So I think that's kind of a little bit two-part, right? A lot of leases, and again, a good landlord protection is as part of your lease that the tenant will owe for ongoing rent even after the eviction. So clearly in that case, it's pretty clear that they would owe kind of that ongoing rent, and the questions of, the duties to mitigate and things that we talked about before would come into play. I believe that by operation of law, if you file, let's say I were to file an eviction today, but I don't get a hearing into December, the tenant's probably going to owe me December rent just by operation of the way that those cases work, and the rent is owed. And if the tenant hasn't turned over possession and hasn't given the keys, you do have the right to file that eviction, even if the tenant has quote unquote moved out, because they haven't turned over possession, they can come back. So I think as long as that, there's that kind of possessory interest, you could charge the rent too.
Yeah, I think the one clear cutoff is if the landlord re-rents, right?
Right.
Then clearly that original tenant's liability ends. Yeah.
Perfect. All right. Amy has a client who has a very specific situation that I think is they're probably going to want to call Homeline. The client is to talk with us directly. But it's just about the legality of a break lease fee. And can if a tenant doesn't move in at all, say that they sign a lease, but circumstances happen before they even move in, before the lease term even starts, and so they no longer can afford the apartment. Can a landlord still charge a break lease fee for not even starting the lease?
Yeah, and I'll jump in on this. I mean, you're right. And you can see our number on the screen. You can email. If you're working with a client, the tenant needs to contact us directly. An email is the best probably in this situation. You could help the tenant write the email, and then if they want to share the response with you, then they could do that. But we're going to want to see the lease, all the documents that are signed. The simple fact that the tenant never took possession doesn't mean they're out of the lease. We get that call a lot. I'm supposed to move in December 1, and I've decided that I signed a lease, October 15th, and I decided I don't want it anymore, so I want all my money back. Probably not going to work out for the tenant unless the landlord's able to re-rent right away.
Okay. Anonymous attendee is asking a clarification about if the court should only require a bond or rent posting if the defense is a habitability offense under Fritz, and not just a dispute over whether like the landlord is charging for rent that was already paid or should not have been charging in the first place.
I guess for clarification, are we talking about the tenants filing the rent escrow, or are we talking about an eviction and then the tenant raises the defense?
It sounds like it's the tenant
yeah.
raising the defense.
And just to clarify for everybody listening, Fritz is shorthand for a court case from the 70s, Fritz versus Worthen, which basically says a tenant is allowed to withhold their rent to force a landlord to make repairs. The landlord goes and files an eviction for non-payment. The tenant defends the case, arguing under that Supreme Court case from the 70s, I have the right to withhold my rent to force a landlord to make repairs.
Yeah.
Which I believe this exact issue is being decided at the Supreme Court level, the state Supreme Court level, to some degree right now. So I think it's something of an open question today.
Yeah, and I would say that in the past it was pretty clear that the tenant had to post the amount of rent owed, and they could raise the Fritz defense, and then it was a question of whether or not they the place did require repairs and how much habitability and how much deduction. It used to be that, if the tenant was wrong, I would find that judges would have the eviction go through. Even if it was that they were wrong in the amount withheld or whatever, the eviction would then go through. So.
And I think specifically as well for this, if it's not necessarily a question about habitability, but say the tenant is claiming that the landlord raised the rent without proper notice, and so the tenant is being evicted over that portion of rent that they refuse to pay. So it's not a habitability issue, but it's an issue of whether the landlord is entitled to that increase or not. Do they have to post that disputed amount? I think is what is being asked here.
Yeah, so when I've seen evictions for non-payment of rent, generally the amount that the tenant is required to bond over, at least in rural Minnesota, judges can't really question the amount per se. It's the amount that the landlord has written in. So the judge doesn't really get into the question as to whether or not it's proper notice or it is the correct amount or whatever. That's a trial issue, but the bond will be required.
Thank you. David has a really interesting situation about related to attorney's fees. So it sounds like David is an attorney, and they had a tenant who they were working with that had a eviction filed for non-payment of rent that the tenant was able to pay off and redeem and have that eviction dismissed. But then the landlord added on those attorney's fees in addition to those $5 limits that are placed onto the tenant's ledger for the next month. And so when the tenant went to go pay their rent for the next month, they were in fact short $600 because of the attorney's fees that the landlord had tacked on as well. And the landlord filed an eviction again for non-payment of rent because the tenant didn't pay everything. Those attorney's fees ate up a bunch of their rent payment.
And I'll have Mike jump into this one too. I think that you're getting into kind of a depending upon the court and the judge, because technically that is not rent. So saying that the landlord didn't, or saying that the tenant didn't pay rent may not necessarily be true depending upon how the tenant paid. Because if the tenant wrote a check, let's say, and they put in the memo, let's say the rent was $800 and they wrote the check for $800 and they put in the memo rent and the landlord cashed it, that tenant arguably paid the rent, right? It's the fees that are the problem.
I guess I'd answer it this way. If I'm a
so-
landlord, if I'm a landlord attorney, I would never file an eviction just for that.
Right. I think you can collect it. I think it's collectible and you can go into conciliation court and get a judgment and all of those things. But I think in terms of the rent and saying that you didn't pay rent, I think you're probably going to lose an eviction court.
Yeah. No, I would not like that footing as a landlord lawyer. If that's the only thing I'm seeking, tenant paid everything else except those attorney's fees, that dollar number. That's trying to bypass the redemption statute would be my argument as a tenant attorney. I would never make that argument as a landlord attorney.
I could see some judges in rural Minnesota, you might get away with that, but I don't think generally it's a good practice. I think that you're probably better off collecting on the judgment or taking it out of the security deposit at the end.
That's the more likely answer, right? Yep.
Fabulous. So Tammy is wondering, so if the tenant is evicted, do the abandoned property rules apply?
There are rules in the eviction statute for what you have to do with the property when the tenant's evicted, and like if a writ of recovery is issued, you have to sheriff inventory and things like that. So it depends, again, you should follow the rules in the eviction statute if you did the eviction, and you should have the sheriff inventory the property. And there's usually like a $25 fee or something, depending upon the county. The fees range a little bit. There's also a writ of recovery fee, but then you would follow the timelines under the eviction statute versus just a general abandoned property.
And so, kind of linked with that is another question from Anonymous is asking, isn't the law enforcement inventory of abandoned property only available in the case of an enforced writ?
No, because tenants can move out and leave abandoned property behind, and then you have abandoned property.
Straight up.
Straight up. And then it's a different notice. It's a different type of notice and different rules apply. But if you're talking about an eviction and a writ, then generally the best practice is to execute the writ and have the sheriff inventory the property and then store it for 28 days pursuant to the statute.
Yeah, I just got a message, by the way, on the last question that we were talking about, the attorney's fees being charged. Sam Spade, one of the attorneys in our office, sent me a message saying that was actually decided in the Court of Appeals that a landlord can't do that. What we just were talking about, what I said a landlord attorney never should do. Apparently, the Court of Appeals really agrees with
Also
that.
agree.
Yeah.
And I would say once the Court of Appeals says it, then it doesn't
Yeah.
matter what court you're in.
Yeah.
You're
And
gonna
it doesn't
follow
matter
it.
what Mike and Jess say either. It's the Court of Appeals
Right.
at that point. Yeah.
I've learned very early on, my opinions don't count.
None of ours do compared to courts. Yeah.
Right.
Kind of going along the abandoned property issues, is there a best practice that landlords can follow for distinguishing what is garbage versus property versus abandoned stuff versus personal property that should be stored?
The
Or
bottle
are
of
you
ketchup question.
Yeah.
Yep, it is. It is. Yeah.
Yeah.
What do you tell your
I mean,
clients on this, Jess?
you know, I've had some different situations where this comes into play. So I kind of caution it on that. I've had people who have had family fights and try to turn it into landlord tenant law, which is always super fun. And I really hate that. You know, and it is the bottle of ketchup question. And then they call back the next day and say, well, we found meth. And I'm like, well, great, call the police and document it. And they're like, well, the police told me to just throw it away. And I'm like, no, force them to come out and take a report, because if I get into a fight over whether or not something's destroyed and it's a chemical problem because of meth, I want some documentation and some proof versus, you know, just some plates left in a cupboard, right? Those are kind of different lands. In terms of like plates and old food left in a sink, I think like if you're going to have an infestation problem and you're going to have, you know, mold and stuff and things, I think, you know, we can call that trash. And I don't think that you're really going to have a whole lot of problem, but I think you start walking some lines. So I suggest that you take photos of what you're doing.
That's it. Photos, by the way. Most of the courts that we deal with in landlord tenant law, they don't really want to watch a video. They just want to have a couple still photos. Not 100, 5 or 6 are fine. Yeah.
Also, the new court system with the uploading of exhibits and things, when you upload your videos, just so you know, it plays really slow on the back end. So the court really does not like your video.
Right.
I'm married to a court clerk. He really hates your videos.
Oh, what the judge likes the least is I have a video. It's 20 minutes long, and at the 12-minute mark, you'll see this. They don't want to do that.
No.
And is there any way that a landlord and tenant can agree to waive that 28-day requirement?
Well, under the statute, it's not waivable. I think there is one way around it, which is the landlord could pay the tenant for their stuff.
Yeah.
Which is something I've always advised. Landlords always look at me like that's the dumbest thing anybody's ever said. But what do you want to do? Do you want to have the debate about whether you have to keep that bottle of ketchup, or do you want to just give the tenant $20 for all the stuff they left behind, and then you can throw it away if you want? Which is what most landlords want to do. They don't want to store the stuff. They don't want to sell it. They just want it gone.
Yeah. Yep.
Perfect.
And then I would be very clear if you agree to something like that, that you both are in agreement with that, because you don't want to have a tenant come back and say, my stuff was worth more.
Yeah.
And
Oh, you'd
you're
want that
saying
in
they
writing
agree.
for sure.
Have it in writing.
Yeah.
Yeah.
Mhm. All right. And then, so Sherry's wondering if an entire rental building unit, and this is probably more for Mike, but is having constant pest problems, roaches, what is the amount of time before a tenant should file a TRA? Or is there a better way to get the management to correct this issue?
Yeah, I'm not a giant fan of TRAs. Those are complicated. It's short for tenant remedies action. They take a lot of effort to compose the group that's able to file the TRA. I much prefer a rent escrow where one tenant can go file the case. If you have a group of tenants that want to file the same thing, it's really powerful to the court if you all file a rent escrow at the same time, and it's much simpler to start the case. So with a rent escrow, the tenant simply gives a 14-day letter. We have those on our website. It's the most downloaded thing on our website is the 14-day repair demand letter. And again, that sort of group approach to solving that problem. You'd all hand in the 14-day letter at the same time. So there's a little protection almost anonymously doing it when you're in a group of 10 people versus one person handing in the letter.
Perfect. All right. And I am trying to put some of these statutes into the chat just so that, since I know we've got several lawyers on, if you want to go have some delightful reading, Minnesota statute, I'm putting in the links to those statutes about the abandoned property and the different rules beyond that. And I will grab the one about rent escrow processing. So Kelly is got a clarifying question about partial payments. We've been told some landlords are being advised to not accept partial payments since they could lose the court hearing. Is this correct? As a service provider, our goal is to work with clients to continue making payments towards the balance so they don't fall further behind, and avoid any additional late fees. Since most hearings are at least 2 months out at this point, that is more of an issue. I guess, do you have anything about why someone would be advised, beyond the potential, they just don't have to if they don't want to?
Yeah, I mean, again, landlords might lose a case for a partial payment defense. And so, especially once the eviction is filed, it's kind of risky for a landlord to take a partial payment, depending on how the lease is written and the contract conversation between the tenant and the landlord. From the tenant's perspective, I mean, I talk to tenants like this all the time right now, in this really unique situation historically where evictions take so long to have happen. It's save the money. Just because you're not giving it to the landlord doesn't mean it's yours to go spend on whatever you'd like. You need to save the money for when it's time to actually have the court hearing, and you can pay everything up front, or maybe you owe $5,000 and you got $3,000. A payment agreement is much more likely to work between a landlord and a tenant at that point if you've got a substantial portion of the money, and then you can sort of show the landlord a potential payment plan that you think you can live up to based on your income coming in.
And I'd be very clear in any sort of partial payment post eviction. I don't like from the landlord's perspective taking the partial payment. But if you do work out a settlement agreement with your tenants, that you're very clear about the dates and times and things that you're going to be paid, because you don't want to get into a question of, I thought it was going to be the 16th at 8 a.m. and the tenant thought they had till 5 p.m. You want to be very clear about dates and times and when things are due in any sort of settlement agreement.
Yep.
Fabulous. All right. Sherry asks, is a 3-day notice to evict legal?
Short answer is probably no. This is probably from a landlord that has property in other states. North Dakota specifically has a 3-day notice mechanism in place. But a 3-day notice is probably not necessary for a landlord in order to be able to file an eviction. We see sometimes landlords say either pay up in 3 days or else I can go file the eviction, which in all but 3 cities in Minnesota isn't going to be required. The landlord doesn't have to give any notice at all to go file an eviction for non-payment. So 3-day notice probably doesn't mean anything legally. Almost certainly doesn't mean anything legally in Minnesota.
I do say that judges do like to see a landlord who works with the tenant. So if the tenant is falling behind, you may want to give a notice and say, hey, this is the amount of rent owed and the late fees and things. Please pay. It's not necessarily legally required, but I do think that it helps your eviction case and giving the tenant a chance to cure before you file.
Oh, and it
Because a
really
lot of
helps naming that number, like you say, Jess.
Yeah.
Absolutely, because tenants get behind, especially in COVID era. The tenants literally have no idea how much they owe. They really just don't
Yes.
anymore. And so telling the tenant, here's the exact number, maybe even a quick breakdown of it, makes a lot of sense from even if the law doesn't require it, it makes sense for a landlord to do it, because landlords don't want to file evictions.
It's not a financial win. It's not a financial landfall for a landlord to file an eviction. So I will say in that sense, and then, especially with the kind of coming out of COVID era, a lot of judges are encouraged to kind of bend over backwards for pro se parties. And you may find yourself asking, if you want to settle with a tenant and things like that. And if you've tried to, you can show that, look, I've tried to do this before I came here. You'll save yourself a lot of time and headache.
one thing I want to add to that as well. So there are some specific rule requirements for manufactured home parks when it comes to notice. And there are some specific rules for terminating tenancy at will for non-payment of rent as well. So, but that's not necessarily terminating is not necessarily the same as evicting. So, but
Yeah.
I
And
want
I'd
to
be
throw that all
careful-
out there.
I'd be careful in how you characterize it as a landlord too, in terms of giving reference, because just because you gave a notice doesn't mean you did an eviction, and you don't want to end up giving an improper rental reference. So you want to use the terms correctly.
That is clutch. All right, Sherry's also asking, what is the legal process for a landlord to raise rent on a tenant during a lease term? Does this process need to be in the original lease?
Yeah, so the short answer here is it's probably got to be the same amount of time. It's got to be in writing. It's got to be the same amount of time as if one of the parties were trying to give notice to vacate. So if a tenant's supposed to give a month's notice, a full rental period's notice to vacate, the rent increase notice has to be at least that amount of time. There could be something else in the lease as well. But look at the lease, but the best guess is usually however much notice somebody needs to give to vacate, that much notice needs to be given for a rent increase as well. Note, St. Paul has rent increase rules in place now. It's the only city in the state that's really limiting that.
Okay. So, Anonymous is saying, so the whole thing about different judges, are there different rules? Are the rules different per county, or is it, how does that work?
Yep.
You really want to know the judge. That's how that works. That's the advantage of hiring a lawyer. You really want to know the judge and the judge's preferences. Ramsey and Hennepin have housing courts. And so it's a little bit of a different world than rolling into a district court. And I say this in the sense of, you know, coming out to rural Minnesota and trying to enforce some things that I did in the cities and things like that, you know. From the landlord side, I always get landlords that said, this is the way that I've always done it. And, you know, kind of wild, wild west. And to that I say, well, that's great. That just means you haven't been caught and you haven't been sued for it. So you want to kind of make sure that you're following the state laws. And I say that, you know, with any court case, regardless if it's family law, it's housing, it's expungement, it's anything, each judge kind of has to stay within the lanes of the law, but they also have ways that they do things. And so knowing what the judges and things in your area do is really important. And that's just kind of why I say that, is that, you know, more so in a district court versus a housing court, it's really going to vary from county to county.
And judge to judge.
And judge to judge.
Absolutely. Yeah.
Yep. All right. Well, that is kind of it for, we had one other question about housing choice vouchers that we are not experts in housing choice vouchers. So that is going to be a question that you are going to need to discuss with probably legal aid is a good place to go with those types of questions. Otherwise, there was a whole bunch of thank yous from folks saying thank you so much. They've learned a lot. So, and I agree. Thank you so much, Jess. Thanks, Mike, for taking the time here to talk to us about your insights into this whole chapter of law from a bunch of different perspectives. It has been really helpful and I really appreciate it. So again, thank you all for joining us here today. This will get posted to our website, this recording in a day or two, depends on how long it takes to get out to our cloud. But again, thank you so much and have a great rest of your day.
Thanks,
Thank
Jess.
you. Thanks. Good to see you guys again.
Bye.